it's so good to see so many of your friends of this project back again together in this public gathering. We meet in a time of peace. We don't know what the public peace will be a week hence, in the aftermath of the election. But it's just struck me also that we're still meeting in the daylight. It's still light before the time changes. So it just struck me a moment ago, and it brings back that old story from the 80s of this people interviewing these pilots under intense schedules for their jobs. One woman asked the pilot, "Your life is so intense. Do you remember the last time you made love?" He said, "I remember it exactly. It was 1958. He said, 30 years ago? Well, no, it's 22:30 now. So here we are at 17:30. But right now we're here to celebrate several things, including the 11th year of this project, and we can tell you that we're not burdened by anything in our past. And looking back, as the saying goes, there's not a thing that comes to mind that I would change. I should be clear, I want to get on the record. I was born into a middle-class family. With a father who was a foreman, so they were aspiring to be a middle-class family. But that's not what we're here tonight. We're here to mark a new phase with the advent of my dear friend Gerry Bradley, who has been liberated from Notre Dame after shaping so many young lives of lawyers. He's been receiving an outpouring of gratitude and appreciation. And he'll be joining me now full-time in directing and shaping this James Wilson project in natural law. And it's my privilege here to introduce him to talk tonight, but I should drop back to put a couple of things on the table. I rarely quote John Stuart Mill, but he did notably say that we stop using the language of like and dislike and begin using the language of right and wrong as we think someone may rightly be punished for what they're doing. Or if we have a chance of stopping him in advance, an injunction comes into play. Of course, we hold back in prudence from making every wrong illegal, but that doesn't free us from the need to explain the ground on which we would pronounce certain acts as so wrongful that the law would be justified in reaching them. As Aquinas warned us, some vices may be so intractable that we can't hope to obliterate them without powers of the government that none of us would suffer. As he said, the task of the law may be to bring people to virtue, not suddenly, but gradually. But even for things that the law found hard to obliterate in the past, certain DAs, like the late Frank O'Connor in Manhattan, would at times surprise people to zing a prosecution of an abortionist on the East Side, just to make the point that the law is there, and there really are limits. One of my dearest students, Tom Davis, Amherst 71, who was part of the Republican leadership in the House and involved in D.C. affairs, was having an interview recently with someone in the D.C. government and said, we really have to take seriously this matter of carjacking and crime. And what the fellow said was, "Oh, you mean you want more young black men in jail?" And there you could see and hear the state of mind of some of the recent progressive DAs, an aversion for different reasons for bringing down the hammer of the law, even at the expense of innocent victims. So it's quite tempting to ask, what lessons do you see yourself as teaching to young black men early in life that they can have the excitement of crime and the benefits of the crime at no cost? I mean, what can these people in high office possibly see as the path to shape the moral culture of a new generation? And as they recede from punishment or the sting of punishment, do they undercut the sense that there's indeed something truly wrong about these crimes? Do we lose a sense of their wrongness? Now, unlike most people in the academy, Gerry decided to launch his vocation in the law not by taking up a clerkship, but by joining the shop of Robert Morgenthau, Amherst College, class of 42, the DA in New York City, when Gerry was taking on the life of a young prosecutor. And there he dealt with the everyday life of the law, with the kinds of cases, tawdry and unbecoming, that make up the life in the city, yet through it all, I think, coming to hold even more firmly to the kind of life that the law, rightly aimed, seeks to sustain for us. He absorbed lessons about life and law that most of his colleagues in the academy would not absorb. But unlike them, he also brought forth a body of writing with philosophic substance and depth. And he brought forth his teaching with the keystrokes of a gifted writer. He didn't take up a clerkship, but a few of his children have, including 2 sons at the Supreme Court. Gerry and Pam, his fellow student at the law school at Cornell, have now given us the gift of several truly accomplished young lawyers. But Gerry himself did not take up the signing bonuses. They came along with those clerkships. Gerry's done several books, including a collection of his essays on law, religion, and morality, The Unquiet Americans, on Catholics, Moral Truths, and the Preservation of Civil Liberties. But the book I'm plugging for is the book, and the movie, sure to come out, of his recent magisterial article, Moral Truth and Constitutional Conservatism. We had a couple months ago a celebration of Gerry's work in San Antonio, and we just had another rich celebration of his work and the shaping of his lives, the lives at Notre Dame. But I actually think we're on the threshold of a fuller celebration and appreciation for the writings still unfolding. Through it all, he's remained the voice of moral clarity, trying to break through conservative jurisprudence, with the clarity becoming, I would say, even stronger and more crystalline. And so would you join me in welcoming Gerry this evening, this full landing now. With James,
Well, I forgot to mention to Hadley and Garrett and the others concerned, Michael, that I don't want to follow Hadley anymore to the microphone. It's really an unenviable task. I mean, just to play in Hadley's league, the ante is you have to be certifiably hilarious. And by the way, Hadley says I was liberated from Notre Dame. Now, it's true that more than a few liberal administrators at Notre Dame over the years, I've been there 32 years, would have liked to have bound and gagged me and thrown me in the cellar. But by liberated, he means I've retired, more or less voluntarily from Notre Dame. But I feel a great deal of pressure this evening, I guess for 2 reasons. One, I've already indicated, and that's I feel a great deal of pressure to be funny, because Hadley's very funny, and he set a very high bar for me. And also, just 15 minutes ago, we were talking in the back of the room. Paul DeHart where's Paul hiding? There's Paul. So Paul says to me just 15 minutes ago, right over in that corner, he says, well, I told my wife that, I was going to be speaking after you. Now, Paul's speaking tomorrow morning. But I told my wife, and she said, well, if you're speaking after Gerry Bradley, you're just toast. He is so funny, she said. And it reminded me of the first time I had this problem. It's about 30 years ago now. But there's a now deceased but venerable philosopher at Notre Dame, Ralph McInerney. Some of you know who he is. Maybe a few of you knew him. But Ralph was an amazing Renaissance man. But he installed me as the vice president of a scholarly organization of which he was the president. And at our first annual convention in front of hundreds of people, and on the way in from a liquid dinner, at least in my case, a liquid dinner, he surprised me as the group was assembling for this big set of talks. He said, I think you should say a few things to the group. And I blubbered something to the effect, well, gee, Ralph, I really haven't prepared anything, and I'm new to the group, I really don't know the group, and besides, I'm drunk. And I swear, Ralph said, it doesn't matter. Say anything you want, so long as you're very, very funny. But the other source of pressure is that I'm about to give you a paper on sentencing, what amounts to the philosophy of sentencing, talking about punishment, retribution, and progressive prosecutors, of which I was not one, by the way, when I worked for Morgenthau way back when. But I think I have something to add to the conversation, but it is a bit intimidating to be in the presence not only of so many sophisticated people, many of them lawyers, several philosophers present, and then we have quite a few federal judges present. The appellate bench, I see Alice Batchelder, Rich Sullivan, and then there's this trio just to my left in the third row, and they know who they are, and it's the law firm of Griesbach, O'Toole, and Conrad, all sitting federal district judges who sentence people for a living. So they know more about this than I do. Maybe I can say something that will make them think, or they can help me think. But I'm going to take up a topic at some risk. And lastly, I'm a little bit unsettled because, first of all, Hadley decided to move back this talk from 5 to 5:30 and didn't tell me. And then I had prepared a handout, and I mean a handout. It was a one-pager with 3 passages on it. They're block quotes that now, because we forgot to bring them with us, I'll have to read to you the block quotes, and I promise to read slowly, but it was a genuine handout. Now, yes, I understand any normally well-adjusted person, even of my age, would do PowerPoint at this point, but you'll have to excuse my Amish ways, which go way beyond literal handouts. I mean, I actually have like money in my wallet at this moment. And I read habitually newspapers, which I pick up and cover my face with at the coffee shop. And I rejoice to say I've never tweeted or faced or linked anyone in my entire life. With that, let me turn to the topic at hand, which is progressive prosecutors. And the only thing I have on the judges and I knew Rich Sullivan is a former prosecutor, Bob, of course, Bill, maybe all of you, Dermot. I don't know if all of you have been prosecutors, but I do have, I think, one thing on my resume that you guys probably don't have. Okay, be honest now. How many people here have prosecuted the guys who run peep shows? Oh, okay, 1. Okay. Now, how many people here don't even know what a peep show is? Good. I mean, I hope some people don't even know what I'm talking about. Okay. Enough frivolity. Let's just get humorous. Okay. Now, George Floyd's death at the hands of Minneapolis police on May 25th, 2020, touched off the most sweeping reform of America's criminal justice system during my lifetime. And mind you, I'm on Medicare now. What's happened in just the 4 years or so since is more sweeping than the Warren Court criminal procedure revolution of the 1960s. Think of the exclusionary rule, the right to counsel case, Gideon versus Wainwright, the lineup cases, and of course Miranda. I think it's more sweeping these last 4 years too than the transition during the 1970s from indeterminate sentencing rooted in rehabilitative ideals, back in the day when you could get a zip to 10 sentence, which meant you were locked up to 10 years until some expert came along and said, okay, his mind is right. The transition in the 70s under the pressure of crime out of control to long, determinate sentences for the sake of public safety. But what's happening now, and has been happening for the last few years, is more sweeping than all of that, both horizontally and vertically. Horizontally, in that the whole criminal justice system is up for grabs, from which actions should be criminalized all the way to prison conditions. In between lie plea bargaining, bail reform, discovery practices, sentencing policies, and of course, the police use of lethal force. Vertically, in that not only are all these practices under a microscope, it is that the review under that microscope is relentlessly critical and morally normative, a matter of fundamental justice and not about efficiency or crime control. In fact, the moral legitimacy of the entire system is being arraigned. And the leading accusation against the system is structural racism. Today's reformers focus on what they call the carceral state. True fact, 1/4 of America's young black men are presently entangled in the criminal justice system. They're charged with a crime, they're on bail, they're serving time, they're on probation or parole. In some cities, that percentage is 1/3. You can call this carceral. You can call it whatever you want. By any name, it is a catastrophe, not just for Black Americans, but for all Americans. Now, standing athwart this carceral state is the progressive prosecutor. And I'll just say this one time, every time I use the word progressive, it has quotes around it. Self-styled or so-called progressive prosecutors. But I'll leave out that caveat here on out. His or her stated aims are reducing mass incarceration and racial disparities in the criminal justice system. One scholar writes that progressive prosecutors seek to move beyond punitive measures and prioritize rehabilitation, community engagement, and reducing racial and socioeconomic disparities within the system. Another scholar says that these reformers, progressive prosecutors, understand that criminal law cannot nor ever will right social wrongs or balance unequal political and socioeconomic systems. They use their power to shrink carceral institutions or perhaps try to do away with them altogether. Now, progressive prosecutors, so-called, in San Francisco, St. Louis, Chicago, Los Angeles, Philadelphia, my native Brooklyn, and in Manhattan fit, at least basically, this description. They have decriminalized many misdemeanors and jail no one for the others, that is, for the rest of the misdemeanors. Prison is the last resort for a carefully curated roster of felons. Brooklyn District Attorney Eric Gonzalez, for example, says that, and I'm quoting now Gonzalez, over-incarceration disproportionately affects persons and communities of color. His initiative, which he called Justice 2020, aims, in the words of the initiative, to establish community-based alternatives to incarceration. Gonzalez vowed to change the office culture, that is the culture of his office, the Kings County DA's office, so that ADAs consider non-jail resolutions at every juncture of a case. According to Gonzalez, ADAs should determine in each case what intervention would result in the accused party taking responsibility and making amends for the harm they have caused, and most importantly, to deter future criminal behavior. Prison can be appropriate, Gonzalez added, but only for dangerous individuals who engage in predatory behavior or who pose a threat to public safety. Manhattan District Attorney Alvin Bragg declared in his Day One memo, the memo he issued to his assistants on January 2nd, 2022, when he came into office. In the Day One memo, Alvin Bragg said that over-incarceration has not made Manhattan safer. New Yorkers deserve to be safe both from crime and safe from the dangers posed by mass incarceration. Bragg directed his assistants not to seek a carceral sentence other than for homicide or other cases involving the death of a victim, a felony in which a deadly weapon causes serious physical injury, or involving domestic violence, felonies, and sex offenses, public corruption, rackets, and major economic crimes. Close quote from Bragg. I would add, and evidently for any charges against Donald Trump. Now, Bragg added that even for crimes where his policy against prison didn't apply, he said there's no presumption in favor of incarceration. The office, the Manhattan DA's office, which once employed me, no longer prosecutes minor offenses that the district attorney believes have no impact on public safety. So if you read the papers, even occasionally from New York, you recognize that Paying for the subway and the buses and paying at Walmart and Target is totally optional in Manhattan. Well, I think a profound crisis of moral legitimacy is upon us, but it's not the one progressive prosecutors identify. Sobering as is the size of our prison population, and grave as is the challenge of racism in criminal justice or any place. Progressive prosecution is the crisis. Eschewing prison so far as they do is bad enough, but that is symptomatic of the profound tragedy of progressive prosecution, of progressive prosecutors, which is that they don't believe in punishment at all. Punishment is rarely mentioned in their manifestos, and then only with negative connotations. Punitive in all its cognates are just so many dirty words. Brooklyn's, that is Gonzalez's, Justice 2020 says, accountability is the goal, not punishment. But punishment is how we hold criminals accountable. Now, progressive prosecutors think, they seem to think, that by repudiating punishment, they have answered the burning moral question raised by criminal justice. But they have instead created what I believe to be, after abortion and the decimation of marriage, the gravest moral crisis facing our political community. For even if you squeeze the last vestige, the last ounce, the last drip of racism out of criminal justice, you would still have police, prosecutors, prisons. Our prisons would still be, at least for the foreseeable future, packed with men, mostly men of color. The question is, what justifies public authorities in visiting this catastrophe upon minority communities? Leave aside jail and prisons. Every criminal conviction carries in our society still a certain moral stigma and some collateral civil disabilities. The social and economic costs of having a criminal record remain high, especially in our liability-phobic, totally wired culture. Years ago, a released prisoner could move on to a different state and get a fresh start, more or less anonymously, maybe even under a false name. Now, maybe now you can run, but you certainly can't hide from a criminal past. There's zero prospect of that. Even if one is never convicted, and even if one is convicted and receives a non-custodial sentence, just spending a night or two in jail, waiting to see a judge at arraignment, can be harrowing. And in 2022, over 7.3 million Americans, people in America, were arrested. On what just basis, what morally satisfactory basis does public authority impose these harms on so many people? The great natural law theorist, my former colleague at Notre Dame Law School, John Finnis, asked, why a man's criminal guilt entitles the state to do certain acts which would otherwise amount to direct attacks on basic human goods of a person. The late Oxford legal philosopher John Gardner noted what he called the prima facie barbarity of deliberately damaging people's lives by punishing them. Just so. If you're going to do this to people, you better have a damn good idea, a clear and precise and compelling reason for doing it. Now, calling this regime criminal justice, millions of people, 2 million in jail, 7 million arrested, calling it something, anything other than punishment, just won't do. It doesn't move the ball up or downstream. Leave aside words and all cognates. We still need a compelling moral justification for the coercion and harm that our criminal justice system imposes upon millions of people every year. Anti-racism doesn't help. It has zero tendency to justify putting people, especially people of color, in jail or prison. It won't do to say we're just trying to help people who have gotten into trouble, for that assumes that convicting people and then forcing them to get help, often in prison, often living with their new best intimate friend, Randall, the tattooed skinhead, it assumes that doing that to people to make them better is morally okay. Deterrence is morally fraught. It smacks of using some people for the benefit of others. Deterrence basically amounts to the answer to the question, what do we have to do to this offender to make other people stop what they are doing or would otherwise choose to do? How do we use this person to threaten them? Now, putting really dangerous people away for a long time, what's often called incapacitation, is morally justifiable, though more on grounds of collective self-defense against a sociopath than on any kind of entailment or theory of punishment or sentencing. It's really a matter of defense. Mediation between offender and victim is a worthwhile thing to do. People call this, I think, restorative justice, but it doesn't justify imprisoning anybody. Now, contrary to what the progressive prosecutors say, the burning moral question is not that 2,000 people are behind bars. The burning moral issue is that anyone is. How can progressive prosecutors justify their part in this vast apparatus of coercion and privation, especially since they reject, as they do, unequivocally, repeatedly, they reject retribution, which they equate with punishment, which they equate with pointless suffering? The answer is they can't justify the apparatus of harm. Now, your first-year criminal law professor probably told you about the 5 or so, what he or she called theories of punishment or goals of sentencing. I've already mentioned them in passing: retribution, deterrence, incapacitation, rehabilitation, restoration. Now, my thesis, my argument to you, is not so much that retribution is the best of these several theories of punishment, although I think that's true enough, or true as far as it goes, or true in a sense. What I'm saying is that retribution is the only account of those 5 or 6. It's the only account which is actually a theory of punishment. Only retribution shows you how these harms, privations imposed by public authority constitute or function as punishment. Retribution explains what punishment is and how it is a just social response, a corrective really, to the invariable wrong present in every criminal act. Okay, so that's the thesis, that you can justify these harms as punishment, but not as anything else. And retribution is the only theory that tells you how, why, and on what grounds these harms constitute punishment. Let me explain a bit more about the thesis. Thomas Aquinas described punishment as akin to a cure. He used the word medicinal. He had in mind the offender's reform, and I think what we today would call deterrence. But above all, Thomas had in mind the healing, when punishment is in view, the healing of a disorder, an unjust inequality introduced into the whole community by the wrongdoer's conduct. Remedying this injustice of the crime gives punishment its defining characteristic. Another smart Catholic, Pope Pius XII, wrote that the essence of the culpable act is the free opposition of the criminal to a law recognized as binding. It is the rupture and deliberate violation of just order. Once done, the crime is impossible to recall, Pius said. Nevertheless, he said, insofar as it's possible to make satisfaction for the order violated, that should be done. For this is a fundamental exigency of justice, whose role in morality is to maintain the existing equilibrium. If it is just, and by doing so, by punishing, it restores the balance where upset. Now, the Catholic Church has said very little about retribution, and for that matter, criminal justice. Since the Second Vatican Council concluded in 1965, the Catechism of the Catholic Church says that the primary aim of punishment is to redress the disorder introduced by the offense. Pope John Paul II said much the same in his 1995 encyclical, Evangelium Vitae. But these phrases, redress the disorder caused by the offense, are isolated statements, kind of derelict phrases, floating around, and effectively they're cryptic without an accompanying explanation. As I think, and here I'm going to be up against the law firm in the third row, I think the federal sentencing guidelines reference, among other considerations, to what they call the guidelines label just punishment, which doesn't mean mere punishment, but I take it morally justified punishment. But the phrase by itself doesn't tell you anything that you really need to know. The philosophers have not done much better. HLA Hart student Herbert Morris wrote a terrific article in the Philosophical Journal, The Monist, in which he envisioned punishment as retributive by having, as Morris described it, the restoration of equality as its point, equality between the wrongdoer and the law-abiding. Morris wrote in 1968. His argument was taken up a few years later by Geoffrey Murphy in an article, Three Mistakes About Retribution. Murphy wrote that to commit a crime is to gain an unfair advantage over those who do not commit it. Punishment reestablishes the balance of benefits and burdens among the members of society by taking back, at least, doing away with the unfair advantage the criminal gained. Okay, here's the first of the block quotes that would be on your handout, but isn't, or it is, but the handout's not here. But I'm going to read it slowly, and this is my last attempt to fill in, do some of the backfilling needed to explain what retribution is about. And then I'm going to offer a few more observations about retribution, not so much about what it is. So this is from my former colleague John Finnis, writing in 1999. So Finnis says about retribution, the purpose of retributive punishment is to secure that over the span of time, which extends from before the crime until after the punishment, no one should have been disadvantaged by choosing to remain within the law's confines. In brackets, nobody should be made a sucker for being law-abiding. Back to Finnis. Punishment does not negate the crime, but it does cancel out the advantage the offender gained in the crime. The advantage, not necessarily of loot or psychological satisfaction, but of having pursued one's own purposes, even when the law required that one refrain from doing so. So, Finnis wrote, there is point value merit fittingness in thus restoring equality between offenders and the law-abiding and canceling the wrongdoer's unfair profit. Finnis concludes, retributive punishment is the only genuine and justified form of punishment. whatever other purposes of sentencing could be rightly pursued on the precondition of retributive punishment being imposed. So now my words, finish is done. It's all about setting right the wounded relationship between the criminal and everyone else, the entire law-abiding community. This is the sense behind, or this is really why, the plaintiff in every criminal case is the people, right? The Commonwealth, the state, the United States, and not any particular victim or group of victims. And it's the sense behind how or why this vast public undertaking, the criminal justice system, takes its place and operates in tandem on a parallel track with the opportunity for a criminal's victim to be made whole by private action in tort. Now, retribution specifies, describes, tells you the distinctively public wrong in every criminal act. It is that the criminal unfairly usurps liberty to pursue his own interests and plans, contrary to the law. The criminal's usurpation reaps for him an undue edge over other people when they remain inside the legally specified pattern of restraint. And depriving the criminal of this ill-gotten advantage is the purpose, is really what punishment is. It's the purpose of punishment, but it's really what punishment is. Now, one can see, with this in hand, pretty easily, I say straight away, one can see pretty clearly how three leading objections, I don't know if they're the three leading, but I think they are, three leading objections to retribution are really reactions to mistaken understandings of retribution. First, this would be the second of the excerpts on the handout, the fugitive handout. Justice Stephen Breyer wrote in a case, this is in 2015, of Glossop v. Gross, a capital case. It's back in the Supreme Court this term. I think Glossop v. Gross is in the Supreme Court for the third time right now. This is somebody who's been on death row for 27 years. But Breyer wrote in, I think, Glossop 1 in 2015. Here's what he said about retribution. It's the first misunderstanding. So Breyer, retribution is a valid penological goal because surviving relatives of victims of a horrendous crime, or perhaps the community itself, may find vindication in an execution. And a community that favors the death penalty has an understandable interest in representing their voices. Breyer says it may be cruel and unusual even for family members to go through this legal limbo for 20 or more years. By then, the community is a different group of people. The offenders and victims' families have grown far older. Feelings of outrage may have subsided. The offender may have found himself a changed human being. And sometimes repentance and even forgiveness can restore meaning to lives once ruined. Last part of Breyer. Nonetheless, sometimes the community believes that an execution could provide closure. Well, retribution has nothing, repeat, nothing to do with anyone's emotions or the community's feelings. Much less has it anything to do with killing someone to give somebody else closure. Plato wrote a long time ago, no one punishes a wrongdoer from the mere contemplation or on account of his wrongdoing, unless one takes, Plato's words, unreasoning vengeance like a wild beast. But he who undertakes to punish with reason does not avenge himself for the past offense, since he cannot make what was done as though it had not come to pass. Mistaken understanding 2. closer to reality than Breyer, but nonetheless mistaken, is the idea that retribution is entirely, and this is the phrase you see in this criticism, backward looking. One scholar writes, but this is typical of many scholarly and other informed judgments or criticisms, but I'm going to quote one scholar, whereas consequentialism justifies punishment by the good consequences generated by punishment, those good consequences such as deterrence, rehabilitation, incapacitation, the good consequences of punishment are irrelevant to retribution's justification of punishment. But restoring equal relations, equilibrium, restoring a pattern or relationship of justice between the wrongdoer and the offender, that's as forward-looking as any judicial remedy, right? What happened before is the cause and the measure of a remedy. But the purpose of the remedy, be it damages, restitution, a fine, or being handed over to the Department of Corrections, is to bring justice into being, to replace a condition or a state of affairs that's unjust with a state of affairs that is just. Now, this rear view mirror mistake is buttressed by the further belief, 3, also mistaken, although it does have some roots in the writings of Kant and Hegel, that where other theories justify punishment by good consequences, the good consequences are not only irrelevant to retribution, for in that case of retribution, desert is the necessary but also sufficient ground for justified punishment. So desert is not only necessary, but sufficient to justify punishment. This is often described as punishment for its own sake. But all of us sin, maybe not Mary Ellen Bork, but the rest of us sin, and some of us sin badly. Perhaps we all deserve punishment. And depending on how you read the scripture, we all shall be punished, and we're all being punished for Adam's sin, etc. Be that as it may, the fact that we all deserve punishment does not give anyone the right to execute judgment and impose punishment. Apart, I think, from the special case of the head of a household, the paterfamilias, no one has a natural right to punish anyone else. Presume that A, Hadley, misbehaves, and that his misbehavior warrants the judgment Hadley deserves to be punished. But saying that Hadley deserves to be punished is not to say, it just is not to say, that Michael or Garrett or any of the judges in the room or all of the judges in the room together have the right to actually punish Hadley. That's what needs to be justified. That people deserve punishment isn't the issue. What you have to justify is putting 2 million people in prison as punishment. Only certain officials wielding designated powers of public authority, according to a relevant positive law, are really empowered in our society to punish. In the name of the community and on behalf of the community, in the way that retribution describes crime and punishment. Now, diagnoses. That's 3 mistaken views of retribution, which all should be rejected. It doesn't follow that retribution should be rejected. In fact, these criticisms don't really touch a sound understanding of retribution. But here's, I think, one impetus, I call it, blocking any recovery of sound retribution, a retributive view of punishment. It's a flat-footed, wrong-headed humanitarianism. Writing for the Supreme Court in 2022, Justice Sonia Sotomayor, who was 1 year ahead of me at the Manhattan DA's office, and she was in the trial division, did the nitty-gritty work that I did, so she should know better, expressed a common thought about sentencing. The thought, this was on behalf of the Supreme Court, was that sentencing must be bespoke. She asserted in the case of Concepcion versus United States, and this would have also been on the handout, but here's Sotomayor, but speaking for the court. Breyer wrote for himself earlier. This is Sotomayor. There's a long-standing tradition in American law, dating back to the dawn of the Republic, that a judge at sentencing considers the whole person before him or her as an individual. In line with this history, federal courts today generally exercise a wide discretion in the sources and types of evidence used to craft appropriate sentences. When a defendant appears for sentencing, the sentencing court considers the defendant on that day, the day of sentencing, not on the date of his offense or on the date of his conviction. Well, maybe that sounds appealing and high-minded and compassionate. I don't find it so. But individuality or individual considerations to what end? What objective criteria control sentencing of this unique defendant, and of that defendant, and of the third, and the fourth, and the fifth, and the rest of the defendants on that day's calendar? And where is the relationship between crime and punishment in Sotomayor's account, at least so far considered? Should not the sentence be a proportionate counterweight to the wrongness of the crime, that is, to what the person did on the date of the offense? I think it at stake in this, and in every sentencing, is the core meaning of judicial impartiality. I think the core meaning, not the only meaning, but the core meaning of judicial impartiality is that all litigants be treated, so far as possible, by each judge as they would be treated by every other judge. I think this is a requirement of fundamental fairness and equality before the law. Now, there is a better way to affirm the humanity of the offender, and I think we should. Now, in 2003, I wrote an article on retribution, which nobody read, in the Harvard Journal of Law and Public Policy. Now, I wrote then, this is 22 years ago, I wrote then with a much fresher memory of the day I got in touch with my inner retributivist when I was in practice. Garrett, that's not a punchline. That's just a passing phrase. Wow.
If our imaginations run around.
If every audience were just full of people like Garrett, it would be easy to be as funny as Hadley. I wrote 20 years ago. I wrote this in the Harvard Journal. You can go look if you want. I wrote this 20 years ago. The setting was a dreary episode from my experience before a certain judge in New York City criminal court. Also an adjunct professor at a local law school. The judge was known as a notoriously soft sentencer. Indeed, he seemed to have missed his calling to either social work or psychoanalysis. Near the close of one particularly frustrating day in his courtroom, I recalled, in his presence, a principle of successful debate whereby one embraces the stated goal of the opposition of one's opponent and then explains that his proffered means, my means, are the best means to achieve his goals. So, consequently, during sentencing, and this was like, then iconic moment in the movie Network, when Peter Finch, the kind of deranged, frustrated newscaster, gets on the air, and he recites a litany of horrors. This is like the mid to late 70s. And then Peter Finch is this newscaster, and he says, and one of his lines is about, or a lot of his lines are about crime out of control in New York. And one of them is like, people are hiding in their apartments with their TVs and their toasters. And he urges everybody that's watching his telecast, his newscast, to stick their head out the window and say, I'm mad as hell, I'm not going to take it anymore. Well, I had a kind of Peter Finch moment in front of this judge. So I said to the judge, on the record, I argued the best way to help this particular defendant was the distinctive way that criminal justice, insofar as it's meant to help defendants at all, characteristically helps them. And by sending them to some bogus program, not by sending them to some bogus program, but by punishing them. The accused had incurred a debt to society which he had to repay. And by punishing the defendant, the judge would set things right between him and the community. And I said it. And I wrote further in 2003, the judge said nothing. Instead, seemingly coming unstuck in time. His blank, uncomprehending stare struck me much as the empty, vacant look of a cow, munching grass roadside. But not a regular dumb cow. It was more like a dumb cow which had been lobotomized. I concluded I'd clearly gone beyond his experience and beyond that of most sitting judges at that time. Well, I wasn't held in contempt that day. I fear, however, and this is my concluding big point, I fear, however, there's a darker force at work behind the tragedy of progressive prosecution. I think progressive prosecution, the repudiation of punishment as pointless suffering, opposition to incarceration, helping everybody, the whole thing, I think it's a crisis of belief in culpability, a crisis of belief in moral responsibility, in blameworthiness. It's a crisis of belief in guilt. Now, this foundational tragedy, I think, has three reinforcing sources. The first is our society's ambient determinism. Morally significant free choice does not exist. Believe me, this sort of determinism is much more common, much more prevalent among our elites, despite the talk about autonomy and creating your own self. I think the determinism is much more common, even among people, including judges, in the criminal justice system. The second source involves those who are not hard or categorical determinists. It is more for them a matter of a contingent or opportunistic determinism. True fact. Many teenage boys and young men in poor circumstances today face limited, very unappealing life choices and options. Take up the glamorized life of local gangbangers, or instead opt to stay in school, do your homework, work part-time at McDonald's, and then maybe when you graduate high school, if you do, make a bit more than minimum wage at some entry-level retail or service work. Well, yeah, being square is hard work, but shooting people is just plain wrong. And we all wish that these guys had a richer menu of options. A just society does what it can, reasonably can, to make that menu of options come into being. But whatever the status quo is vis-a-vis these options, then there's no reason to doubt that free choices are made by young guys tempted even by the gangster lifestyle. We all make hard choices, something like that, all the time. Tempted as we might be to shirk our work obligations or shirk our parental duties, to be faithful to work and to spouse, tempted to lie, to violate our marital and other vows, and tempted not to stand tall when faced with opposition on something that matters. We face hard choices between actually equally unappealing options, equal to the gangster lifestyle and staying in school and being square. Should I take up a painful exercise regimen or risk the health perils of more sedentary lifestyle? Should I undertake chemo or seek hospice care? Every day in criminal court, every day in Manhattan criminal court, at least years ago, over and over and over again, defendants make free choices between very unappealing options. And the system, including progressive prosecutors, ratify those choices. We call it plea bargaining. You can take the 10 years on a plea or go to trial, and your exposure is a minimum of 15 to life. It's up to you. Now, the reality of free choice is often obscured by another thought pattern, one which does not deny freedom, but which denies culpability, the third contributing source. The thought here is that the so-called free choice of someone who is the victim of poverty and racism to commit a crime is an understandable, defensible, reasonable, even a good response to such a dire situation of victimization. Now, attributing some cocktail of these three beliefs to progressive prosecutors, I think, makes sense of their profound reluctance to actually prosecute. But that doesn't get them off the hook. For someone who makes no free choice, or who chooses what's actually good, should not be prosecuted leniently or convicted and sent to a program. They shouldn't be prosecuted at all. Again, if you don't make a free choice, or if you choose what's actually good, you don't belong in jail. You don't even belong in court. But progressive prosecutors don't close up shop. Instead, they give us an enervated law enforcement, a criminal justice system demented by moral confusion. And the carceral state narrative that they peddle does considerable downstream damage. Told by progressive prosecutors that the system is hopelessly racist, many people of color, I think understandably then, refuse to cooperate with police and prosecutors. Again, told by the prosecutor that the system is racist. I think people of color make a reasonable choice not to cooperate. In all too many cities, technology such as ShotSpotter will detect gunfire. Just a few blocks north of my house in September, ShotSpotter detected over 200 gunshots at a crowded street party. 3 dead, 10 wounded. Nobody saw or heard anything. Now, who does this help? In truth, the criminal law, in its fair but aggressive enforcement, is our society's great equalizer. The criminal law's radical anonymity is the pearl of great price. Any person who kills or hurts or robs any other person is liable to the same charges, the same sanctions. There are no proper names in criminal law. Every person's life and limb and goods count exactly the same. A robust criminal justice system protects the weak against the strong, the unarmed against those who carry weapons. A robust criminal justice system protects the less educated against the credentialed, the less sophisticated against the clever, and most importantly, the poor against the rich. This is the great desideratum, the ground norm, the norm and ideal for prosecutors, to make this promise of equality a reality, to appropriate and to use and protect and nourish and nurture the pearl of great price. This fundamental equality in the criminal law, great as it is, needs to be put into effective practice. No one needs vigorous law enforcement more than do poor people. In our society, that very often means communities of color, because the rich will always find ways to protect themselves. In suburbs, they live in gated communities, often with supplemental private security. In cities, they live in safe neighborhoods behind locked doors with 24-hour doormen. They ride in Ubers rather than the subway. When it looks like trouble outside, they just work remotely. Or they move to East Cupcake, where Andy and Barney can supply whatever police services they need. But wherever the better sort of folks live, they know that bullets from gang shootouts will not penetrate their living rooms, much less their baby girl's body.